Okay, so today I'm going to be doing attempt, and if I do have time, I'm going to try to do three questions that I have sent in the group. Um, just in case I do have Kasun fact checking me, but I do have Abdullah as well. So please do fix me if I say anything wrong. And if you guys do have anything to add to the note or to the discussion of the question, please do add it, right? Ultimately, this is just like a group project to pass criminal law together. Okay, so first off, before I go into attempt, I'm going to try to do the same structure as Jiva Madam did in the lecture and start with what the statute of what the nature of Sri Lankan criminal law is like. This is going to be important not just for attempt, but in general to understand what the scope of the Sri Lankan criminal law is. But I think attempt is a good place to start it because one of the case laws which established the scope was a fact to do with attempt, which is Kacheri Mudaliyar. So starting off with, what is the scope of Sri Lankan criminal law? So the scope, initially we had law, right? I mean, even before that, we had customary law for Sri Lankan penal law. But then with the Dutch, we had the Roman Dutch law. And after that, we had then we have codification, right? Codification with the penal code. Once the penal code, let me know if at any point I start to lag. Lagging a bit. Yeah, give me a second. Let me go downstairs. Okay, I'm really sorry about that. I hope you all can hear me better now. Can I have some confirmation if it's any better?
Yes.
Yeah. Right. So, as I was saying, when we're talking about the scope, at a certain point, the English decided to codify the Sri Lankan penal or the criminal law. And with this, with the penal code, we have section 3, which ultimately abolished or repealed the Roman Dutch law regarding criminal matters. So just remember that in your mind, section 3 of the penal code abolished Roman Dutch law when it comes to the criminal law. So the assumption at that point was, okay, if you have expressly repealed RDL, that means English law must still continue, right? So that was a presumption for a while until we have this case, Kacheri Mudaliyar versus Mohammedu, which basically established that no, just because RDL was expressly removed, that does not mean English law continued. Sri Lankan penal law or Sri Lankan criminal law is absolutely statutory in nature and there is no common law in it, right? So there is common law in the sense as there is a precedent, but there isn't like a criminal law body which is outside of the statutory law, right? So whatever common law we have as of right now is simply interpreting this statutory body of law, not an independent body in itself, right? So if you read through this, what I have written here, in the Kacheri Mudaliyar case, it was established that the English law criminal law principles were not retained in Sri Lanka. Why? What was the rationale that they gave for saying just because so the assumption before was RDL was removed, that means English law still is there. But Kacheri Mudaliyar says, no, English law was also removed and that was implied. The rationale for saying it was an implied removal of it was basically that the intention of making the penal code in the first place was to create a codified, exhaustive body of criminal law. So, if your entire purpose was to codify and make one singular body of law, why on earth would you have a completely independent English law body just existing out there, right? So the court said, no, even though the statute does not expressly remove English law principles, it impliedly removes it by saying that the intention of the statute was simply to codify and make an exhaustive body of law. I hope that makes sense. So right now, when we look at the criminal law, it's entirely statutory in nature. It's the penal code, primary legislature, and subordinate legislature. So let me give examples for these principal legislatures. So these are things like Poisons, Opium and Dangerous Drugs Ordinance, the Bribery Act, Prevention of Terrorism Act, Motor Traffic Act. These create crimes. One second. These create crimes that go outside of the penal code. Subordinate legislatures aren't necessarily those that are created by the parliament itself, but they are created by other authorities, such as the regulatory authorities, right? Sorry about that. Okay, so why is this important at all when it comes to Sri Lankan law? Now, when it comes to the English law, the concept of attempt, which basically means trying to commit a crime but not having fully committed a crime. So when it comes to attempt of criminal law, I'm very sorry. Let me know if I start lagging again. So when it comes to statutorily defined, so what that means is any crime can have attempt. But in Sri Lanka, like I said, it is statutorily defined. So any crime cannot have attempt. So keep that in mind. When you see a question and you feel like, this does not look like a crime which is included in the penal code, or if the question specifically mentions that it's not a crime in the penal code, just keep in mind this general provision of attempt will not apply to it like it would in the English law. Under English law principles, attempt generally applies to almost all the crimes, but in Sri Lankan law, unless it's explicitly stated or under Section 490, it won't apply. I'm sure it is a bit confusing, but when I go through Section 490, it would make a bit more sense, right? Okay, so first off, what exactly is attempt? My notes are everywhere. I will give a comprehensive note in the end of this. I'm really sorry, it's just everywhere right now. But if we're trying to define, how can we define it, right? An attempt is an act done with the intention of committing a crime where the offender takes a step towards its commission, but the crime is not completed. When this intention part comes into mind, this also is a bit contentious because in English law, intention is a must for there to be attempt. And this is the position that Jiva Madam took in her lectures as well. I'm going to preface this by saying it. Jiva Madam's point of view is the English law point of view, that if there is to be attempt, there must be intention. Now, you know, when it comes to mens rea, there are different types of it, right? You have intention, you have negligence, you have recklessness. But according to Jiva Madam and the English law principle in general, for there to be attempt, there must be intention. I'll discuss this in detail. However, if we take other scholars like Glanville, for instance, and the Sri Lankan stance on this, it's not just intention that you need. You can commit or you can attempt to commit a crime with just having recklessness as well. So even when you are looking at this definition, take it with a grain of salt because you don't necessarily always have to have intention, right? This is the definition that pops up if you search up what attempt is because the English law principle is a bit stronger on Google. But still, you can define attempt as an act done where the offender takes a step towards the commission of a crime, but the crime is not completed, completely ignoring this intention part, and it will still be a good enough definition, right? So if I repeat, the definition of attempt that I'm going to go with is an attempt is an act done where the offender takes a step towards the commission of the crime, but the crime is not completed. Did I say anything wrong? So when we answer the question, what do we need to write? English law principle or not? Okay, so that depends on the question, right? Now, if you look at this question right here, it says, consider giving reasons whether Sena can be convicted for attempting to commit an offense under the law of Sri Lanka and the law of English. Why knowing both sides can be important, because if it is under the law of England, then attempt is something that you establish for anything, right? So attempt is generally applicable, happen with negligence or recklessness. But under Sri Lanka, you can't have attempt under all. Am I lagging again? Uh, okay, give me a second. I'm really sorry about that. I hope it's better now, but let me know if it's bad again, right? Terrible connection issues today. Okay, so as I was saying, yeah, I will say it again. So when it comes to the English law principle of it, so here it says, would it be an attempt under the law of Sri Lanka? Would it be attempt under the law of England? Now, in my answers today, I'm only addressing Sri Lanka, but I will write a proper answer where I'm addressing the law of England as well. So under the law of Sri Lanka, attempt is not applicable to all crimes in general, right? Because section 490 very explicitly says the general principle uh, will only address crimes that are there in the penal code, and also crimes which only have imprisonment, right? So it is very limited application of attempt. The second thing where Sri Lankan law is different from the law of England is because under the Sri Lankan law, for attempt, you don't only need intention. You can have just negligence, you can just have recklessness, or you can have intention. In all of these instances, you can commit attempt of a crime. But under the law of England, attempt is applicable to all crimes in general, and you only need intention. The only mens rea possible for attempt under the English law is intention. I hope that makes sense. So, do we have to know both of this? Sort of, yes. When you're trying to define, I would go with a basic definition excluding the intention part. But when you are trying to address the English law part of it, you can say under the English law, the definition of attempt includes intention of committing the crime. Hope that answers your question. Right. Moving on. The general principle of 490. Yes, thank you. Right. So when it comes to general principle, now, okay, when it comes to attempt is defined in two ways. Either it can be through the general principle or it can be through specific provisions, right? So specific provisions are provisions like if you have the penal code with you right now, section 300, which talks about attempt of committing murder. So it's very specific to that crime. However, the general principle encompasses all of them, but not every single crime that's there. It specifically encompasses, if you look at the scope here, offenses punishable with imprisonment under the penal code, right? It's only for the sections under the penal code. And this is again established in this case, Kacheri Mudaliyar versus Mohammedu. So remember, only the provisions within the penal code and specifically the ones which have imprisonment as a punishment, right? So under 490, it also explains what the punishment for attempt is, and accordingly, it's 1/2, the maximum term that you can go for is 1/2 of the longest term of imprisonment provided for that offense. So let me give an example for this. Under section 366 of the Penal Code, we have theft, if I'm not wrong. Correct me if I'm wrong. So we have theft under section 366. A person attempts to commit theft, right? He goes to rob a bank. There's a bank here. He goes to rob the bank, but so close to him trying to get the money out, the police catch him, right? So the police officers have caught him and he could not finish the crime. So the crime was not fully committed, it was halfway committed. Now, in this instance, say that there is no specific section for attempt of theft in the penal code. If I'm not wrong, there is no specific section for attempt of theft. Now, if there is no, do we have? I don't think we have. So if there's no specific section like that, that is when 490 comes in. So the first thing that the court looks into, is this offense part of the penal code? If it is, yes. Second question that they ask, is the punishment imprisonment? If the answer is yes again, then 490 can apply. If the answer is no to one of those two questions, 490 cannot apply. Very simple, right? So the case law for this is Kacheri Mudaliyar versus Mohammedu. Very simple case. We have a person who is trying to transport bags of paddy from the north central province towards the central province. Now, as you might have noticed here, this is not something which could be included in the penal code because there is a regulation which prohibits the transporting of paddy from one province to another except by rail and with a permit. So basically the regulation has two things. If you are transporting paddy from one province to another province, there are two things you have to follow. Either you have to do it by rail and you have to do it with a permit. So this person, Mohammedu, had a permit. But the thing is, he didn't go through rail. Rather, he went by road using a cart. And before he actually went into the other province, he was caught. So what is this? This is an attempt. Now, like I said before, in Sri Lanka, let's assume that this regulation was part of the penal code. Let's just assume. Now, we all know this was a regulation. So when it's a regulation, it's not part of the penal code, right? It's part of a regulation that was put out apparently by the food controller in this instance. But for now, let's assume that this was in the penal code. And this person did not intend to actually break the law, right? He did not intend to do it this way, but rather he was negligently passing through. He didn't know, he wasn't aware that he was committing a crime. He just didn't know, right? He was just passing through and he was just negligent on his end, not to use the rail, but rather to use the car. In this instance, under the English law, he could not be convicted. Why? Because under the English law, you need to have intention, right? Just keep that in mind. I'm just reminding you a point from before, but I'm sorry if that confused you. Okay, so back to this. Mohammedu had a permit, but he didn't go in the way that he was supposed to go. He didn't go by rail. So here, there was a charge. He was caught. He was attempting to pass. So he was convicted for attempting to transport paddy in the breach of a regulation. Here, the problem after this was appealed was if it is a regulation, can 490 apply? Can attempt to break a crime in a regulation apply when 490 only applies to crimes that are there in the penal code? So here the problem is the food controllers regulation did not make an attempt of a crime. Why? Section 490 of the penal code only applies to offences under the penal code. Now, the prosecution brings up a really interesting argument, right? They say under the English common law, any crime is a crime. So, attempt to commit any crime becomes a crime. So, they say, look, we are under the English law because it was the English that brought law in the criminal law into Sri Lanka, and the criminal law of Sri Lanka is based on English law. So the English law principle of attempt to committing a crime must apply to all crimes. It is in this instance the court decides to establish that English criminal law is not in force in Sri Lanka. So this is what we talked about before. The court ruled that English common law of crime is not part of the law of Sri Lanka after the establishment of the penal code, right? Then they also continue to say that there is no general attempt of crime. The penal code is exhaustive, and that means it's only 490 that can cover attempt And if it's a regulation, if it's not part of the penal code, even if it's a subordinate legislation, doesn't matter, right? If it's not part of the penal code, attempt will not apply unless the crime is specified in that subordinate legislature saying attempt of this is actually a crime as well. So let me give you an example. There is a subordinate legislation. Let's take the PDVA, Prevention of Domestic Violence Act. Let's say, I know it's not criminalized, but if there is a section which says attempt of causing harm, attempt of causing harm to an intimate partner is a crime, intimate partner is a crime, then we can convict a person under attempt. But if it only says causing harm is a crime, causing harm to intimate partner is a crime, there we cannot establish attempt. Why? This is a subordinate legislation. I hope that makes sense. Right. So here, this is the rationale and everything is given here. I don't want to go too much into detail. I will send the note later. But the rationale was the same rationale as I said before, which is the legislative intent, right? The enactment of the code was meant to repeal all the laws and repeal all the uncertainty that existed in a law which is not codified. So if you want to remove uncertainty, you won't just remove RDL, you will also remove the English law, right? So that was the rationale that was given. Right. So before we were talking about the general provision of attempt, this is the specific provision of attempt. So some examples are given here. Section 300, which talks about attempt to murder. Section 301, which talks about attempt to commit culpable homicide. Section 158, which talks about attempt to obtain gratification. And Section 383, which talks about attempting extortion. Do you have to remember all of these? No, you don't. But remembering at least two of them will sort of be good moving on, right? Okay, mens rea of attempt. So this was what we talked about, the differentiation between the English law and the Sri Lankan law version. So I'm going to give you the rationale for both of them. So the general rule, that is the English law perspective of it, is that mens rea required for criminal attempt requires intention, right? Because intention is almost always a higher standard, right? The burden of proof for intention is obviously much higher standard than the burden of proof that's there for negligence, because you can be like, oh, he just committed that crime, cool, whatever, he was just negligent. But if you want to prove that he intended to commit that crime, there's a bit more the prosecution has to do, right? So for attempt, the prosecution has to do a bit more under the English law because they have to establish intention. So what is the rationale for English law? The rationale for English law is that attempt means trying, right? If you are attempting to murder, you are trying to murder. So if you are trying to do something, that means you wanted to do it, right? You intended to do it. You can't be negligently, unintentionally attempting to murder, right? So according to the English law, it's logically impossible to attempt something without intending to do it. And that is the position that Jiva Madam was in as well, right? So let me explain that again. If you are attempting to do something, that means you are trying to do it, right? If you are trying to commit a crime, that means you want to commit it, right? There is a want here and there is an intention here, right? Want is not intention, but there's an intention. You want to do it. You're going to do it, right? So that is the sort of mindset that the English law has when it comes to attempt. So let me give you the example here. A man throws a stone at a tree. He understands that there's a risk of hitting a window, but he throws it anyway. So what we see here is negligence, right? He doesn't intend to break the window. He's just negligent, right? He knows the stone might hit the window, but he just doesn't care, right? He just wants to throw the stone at the tree, perhaps because he wants to get a mango or something, right? So he misses the window closely, but can we say that, oh, he attempted to break the window? No, we can't, right? He was just being negligent about it. So if he didn't intend to break the window, he can't have attempted to break the window. That's what the English law says. Now, on the other hand, if the man throws a stone at the window to break it and then misses it, we can say he attempted to do it. So again, that's the English law version of it. But then we come to the more Sri Lankan rationale of it, which is based on Glanville Williams' version of it, right? So Professor Glanville Williams says that you can attempt a crime even under negligence. So the logic here is, if a statute makes a crime under rashness or negligence, and a person takes steps to perform that act knowing the risk, they are attempting to commit a crime. Now, when I read the definition, it's hard to understand, but let me go with an example. Now, you know that your car does not have brakes, right? You know it. You don't want to hit anyone. You don't intend on going out there and murdering anyone, right? You know your car doesn't have brakes, so you are negligent. So your brake is broken, your brakes are broken, but you are just negligent of it. There is no intention of murder. But unfortunately, your brakes give in and then you kill a person. So this person has died. Now, in this instance, murder happened because of negligence. Right, cool. Let's say before this murder happened, before a policeman stopped him, said, stop, can't move. And then he checked the brakes and he was like, oh, your brakes are broken. So in this instance, hasn't he attempted to do a crime, right? What I'm basically saying here is, if a crime is there which is defined by negligence and you were going to do it, you were going to commit that crime negligently, but you were stopped, didn't you attempt to do it? So let's take the example of section 272 to make it a bit simpler, right? Rash driving or riding on a public way, which is under negligence, right? This is not intentional. Rash means recklessness. So recklessly driving is a crime. So while you were recklessly driving, a policeman, like before you had started recklessly driving, a policeman stopped you. But didn't you attempt to recklessly drive? You did, right? So under that, Glanville Williams says, if you can attempt to do a crime which was defined by a mens rea of recklessness or negligence, that means recklessness and negligence can be the mens rea for attempt as well. So I hope you understand the two different rationales for it. Under English law, it says you can't negligently do something because you're trying to do something, and to try, you need to have an intention. Glanville Williams says some crimes are not defined by trying or wanting to do it, but rather some crimes are defined by simply negligently doing it. And in the instance that you were negligently going to do something and somebody stopped you, that must be an attempt. I hope that made sense. If it did not, please put to the chat. I will repeat again. Okay, so now that that part is done, I think that was the most confusing part. The rest is quite simple, right? There's another thing. When it comes to strict liability crimes, attempt can be upheld as well. I will recheck on this source. This was from GLP research book, but I will try to find the full case name of this. But under the case Collier, the accused was charged with attempt to have sexual intercourse with a minor despite believing she was over 16. So this is clearly strict liability, right? So even in a strict liability case, you can have attempt. Just remember that. I feel like it's a bit obvious, but just remember that in case. Right. So once we are out of the box, we are going to deal with actus reus. Now, actus reus on a theory basis has a bit more content, but it's very, very simple, right? Okay. So the thing is, when it comes to 490, if you look at the section right now, you would notice that 490 does not explain the standard for defining what is the actus reus necessary for attempt, right? It simply says if there is an attempt, then that means it should be charged or something. But it doesn't talk about the actus reus necessary or the standard for actus reus necessary for there to be attempt. So we are completely going to base our interpretation of that on case laws, right? So there are different theories that have come up for attempt. there are three broad theories, right? The first theory is the wrongful act theory. The second theory are the proximity theories, and the third theory is the equivocality theory. Under the proximity theory, there are several as well. We have the first stage theory, we have an intermediary stage theory, and we have the last stage theory, right? In Jiva Madam's lectures, what was specifically focused on was the last stage theory and nothing beyond that, but that doesn't mean that is not going to come for the exam, right? So let's go through them one by one. What does the wrongful act theory say? This is not a theory that is recognized by the Sri Lankan law because it's quite an unsatisfactory theory. Under the wrongful act theory, it says the person is guilty of an attempt if he has committed another offense in pursuance of his criminal intention. So let's take this example here. There is a person who wants to commit rape. However, he has, like, let's say there is person A, he wants to commit rape on another woman, right? Rape on another woman. So in order to do this, he trespasses into her house. Trespasses into her house. And under the wrongful act theory, it says, at the point that you have done another crime in pursuance of a crime, that would amount to attempt. So once he trespassed her house, he had already attempted to commit rape. Now, while I'm saying it, you might have realized how silly this theory is, right? Because let's take, for example, the very question that we have here. So let's take this question, right? So I feel like this is a good example to go with. Sena, a musician, is found in the company of 5 children at his residence. Police said that parents have complained that their children are picked from school by Sena, and he drops them back in the evening the same day as it happens often. Police is taking steps to frame charges against Sena for attempting to sexually harass children. So if we use this theory, right, the wrongful act theory, we can very simply say that under the wrongful act theory, Sena should be charged. Why? Because he committed kidnapping pursuance of a crime of sexual harassment, right? So when he attempts sexual harassment, he committed another crime, and thereby that means he must have attempted sexual harassment. But this is a very silly argument to make. Why? Because you could have kidnapped to do something different, right? You could have kidnapped these children to perhaps for extortion of their parents, right? You could have kidnapped these children to perhaps murder them. How are you going to define what attempt is going to be there? You can't, right? If you say under the wrongful act theory, if you committed one crime, you must have attempted another. That's quite silly because you can have attempted so many different crimes. So while this wrongful act theory does stand as a theory, it's just a theory, right? It's not used in a practical sense, but you can sort of criticize it in your answers if you want. Then we have the appropriate stage theory, or we call the proximity theory. So under the proximity theories, like I said, we have 3. Firstly, we have the first stage theory. This is also something which is not much used in the Sri Lankan context, but it can be used because the Sri Lankan context doesn't really subscribe to one of these theories. I'm just generally explaining all of them, right? So under the first stage theory, it says the accused should perform an overt, which means a clear action with the intention of committing the crime. So what does that mean? If the accused tries to commit the crime and does a certain act or does the first act necessary to commit the crime, that means he has attempted the crime. So let me take an example. A person wants to commit murder. According to him, the first step towards murder is to get the murder weapon. Okay, so for him, that is the first step. So that means he has attempted murder. Why? Because in his opinion, his first step to commit murder is to get a weapon. But the problem here, as you might have noticed by the way I'm saying it, is that it's extremely subjective, right? It depends on what the accused believes the first step is. Because for one person, the first step may be to get the weapon, but for another person, he'll be like, oh, this is just a weapon. I'm not going to commit the crime here. I'm just using this weapon for defensive purposes. But then later he gets mad at someone, and then his first step becomes to get like go into that person's house with the weapon. Okay, so that's his first step. So from one accused person to another, their first step can be different. So because the first step theory is too subjective, we say it's generally not too practical, right? So let me take this example that I have here. A hates B and decides to kill. A goes to a shop and buys a knife, specifically intending to use it on B later that day. So under this theory, simply buying the knife will be considered attempt. But that's very inconsistent with the penal code. Why? If you have the penal code with you again, look at section 300. I think illustration 203, maybe it's one, in my head it's two. In illustration 203 under section 300, it says buying a gun and loading it is not an offense until it is fired, right? So section 300 talks about attempt of murder, right? So under attempt of murder, it says simply buying a gun or even loading a gun is not attempt. So from that you understand the first stage theory is not recognized by the Sri Lankan penal law, right? The other one, it says buying poison and mixing it with food is not an offense until delivery. Delivery means you putting it in front of the person that you want to kill. Only when you mix the poison into the food and put it in front of that person does it amount to attempt of murder. But until then, it is not attempt. So you can see from section 300's illustrations, our penal code doesn't really accept the first stage theory. Okay, so then what does our penal code accept? The next one that we have is the perpetration theory. Perpetration theory, or there are some scholars who say intermediary, but let's go with the word perpetration here. Perpetration theory talks about an intermediary step. It doesn't have to be the first act, it doesn't have to be the last. It's not the first, it's not the last, it's just an act in between, right? As you are committing an act in between the first act and the last act, that can amount to attempt. So let's take, for instance, a person wants to burn the other person's house down. You buy gasoline, that's your first step. Buy gasoline. Gasoline. Your last step would be to burn the house. And under the perpetration theory, anything that comes in between can be considered an attempt. We are not going to consider buying gasoline as the attempt, but rather anything that comes between. If you soak a rag in gasoline and walk towards that person's house, if you take a what do you call it? A matchstick and then walk towards their house with gasoline, that's an intermediary step. So anything in between is attempt according to the perpetration theory. But the thing is, again, what are we going to amount to anything in between? Who is going to decide how intermediary this is? Because if you can't define what the first step is according to a person, how are you to determine what the middle step is? How are you to determine what the intermediary step is, right? So in that case, again, perpetration theory is not a very satisfactory theory. Why? There is no standard given to what amounts to an intermediary step. So this does not have a lot of practical value. Then we go into the final stage theory, which was something that was a lot focused on during the lectures. Now, under the final stage theory, we are talking about progressing a significant distance. We call this a dangerous proximity to success. Dangerous proximity to success. That means you're really, really close to committing the crime. So if the crime that you wanted to commit is theft, you are really close to committing it, right? You just have one more step to go. You have committed it already. You don't have anything beyond that to do. So let me take this example. So there are two there are two justifications or rationales that are there for the final stage theory. These aren't two types of final stage theory. These are just two explanations for final stage theory, right? And both of them basically say the same. According to the last act theory, it says the accused must have performed the last act needed to achieve the criminal consequence. So the case that we have for this is R versus White. In the case R versus White, the person wants to poison his mother and kill her. So what does he do? He takes his mother's drink. Oh, man, what an ugly cup. He takes his mother's drink and then he puts cyanide into it. Okay, he still has a lot more acts to go. Just putting poison into your mother's drink is not enough. You need to have delivered the cup in front of your mother and waited for her to drink. Okay, so is there anything beyond that that you have to do? No, right? You have done the last act. It is up to the mother whether she drinks it or not. It's up to unforeseeable circumstances completely outside of the accused uh, completely outside of the accused's actions. Now, if the murder happens or not, the mother perhaps may decide that she doesn't want to drink it because she's not thirsty, but that's outside the accused's discretion, right? He has done everything. He has done the last act necessary for the crime to be committed, and he's dangerously proximate for the murder to be committed. In that instance, we say that an attempt is committed. The possible intervention theory is basically an alternative to explain the final stage theory. It says if the accused can still change his mind, then it is not attempt. So let's take, for instance, you want to send a threatening letter to someone else. Let's say that this is a crime. Now, obviously, this may not be a crime, but let's assume that this is a crime. You want to send a very threatening letter. Okay, so you write the letter and you walk towards the post office. Is that your last act? Not really, because you still can walk back, right? You still have discretion to change your mind. You still have the ability to what we call repent. Repent means go back on your actions and just not commit the crime. So in that instance, there is no attempt according to the final stage theory. But if you went to the post office and posted it, there's nothing more you can do, and there's no way that you can repent anything beyond that. You cannot intervene anymore. So, according to the possible intervention theory, at the point the accused can no longer intervene and no longer repent, that is where attempt is established. Nothing before that is attempt. It's only at the point where he cannot intervene any longer does it become attempt. Now, what is the Sri Lankan stance on this? We have another one. Okay, let's talk about that and then go to the Sri Lankan stance. Then we have the equivocality test. So we did the proximate theories and we did the wrongful act theory. So the final theory is the equivocality theory. Equivocality theory is not a big, like a lot of people aren't a fan of this. But what this says is if the attempt of the act is evidence itself of the crime, then it should be attempt. So let me take, for instance, this example, right? There are two people, they have a gun with them, and they have a note which says, give us all the money that's there in the bank wallet, and we won't shoot anyone. So it says, give us money, we won't shoot. We won't shoot. Okay, so they go into a bank, and before they go inside, they are caught. They are caught by the police officers. Now, if you can, from their actions, just by the face of their actions, prima facie itself, is it obvious that they were going to commit a crime of theft? Yes, it was. Then there was an attempt. But if it was not that obvious that they were going to commit a crime of theft, that means there's no attempt. But that's a very silly way to go about it. Why? Because in some instances, it may not be that obvious that this person is going to commit a crime if you just look at the face value of it, right? But let's say, for instance, a person just has, just has a gun with him and he's just walking towards a bank. Is that unequivocally proof that he is going to steal? No, it's not. So according to the equivocality test, there is no attempt, right? So what equivocality test means is the person's actions must unequivocally or unconditionally hint that he is going to commit a crime. If it does not unequivocally hint that he is going to commit a crime, then there is no attempt. Did I mess anything up? Just preparation is no. Okay, so let me go into that. So that is part of the Sri Lankan law, right? Okay, so that is the equivocality test. Again, not something which is consistent with the Sri Lankan law. When we go into case law, we can look into the Sri Lankan position of this. The Sri Lankan position doesn't say, oh, we like the first stage, or we like the intermediary stage, or that we like the final stage. The Sri Lankan law principle just establishes one thing. There is a preparatory phase. There's a preparatory phase, and there is a phase where you are committing an act or an overt commission towards the crime. So, what does that mean? Now, what is preparation? Preparation is when you haven't made an act towards committing the crime. So, the Sri Lankan law is a bit lenient towards the last stage theory, right? Because for us, doing all of those things like taking a gun, loading it up, going to that place, all of those still preparation, right? Only when you point it at the person and shoot did you try to commit murder. So as you can see, the Sri Lankan version of it is very, very lenient on the last stage theory. But it doesn't always have to be the last stage, right? Because in last stage, it says, under the possible intervention theory, at a point where you no longer can intervene, that is. There is nothing like that in Sri Lanka. It just establishes once you have passed the preparatory phase and you had made an act which is about to commit the crime, that is when we say there is attempt. So let me go with this first case, the King versus Giris Appo, which is a good example of what I'm trying to explain, right? So in this case, let me erase this. In this case, we have the accused. I don't know what a shroff is, but somebody, and he wants to counterfeit notes, which is basically to print money. Printing money is a crime, obviously, right? So he wants to print money. So what does he do? He goes to, one second. Sorry. So under this case, what happens is the person wants to circulate counterfeit money. He goes to the complainant and I haven't explained the case facts clearly enough. He goes to the shroff. The shroff is someone, I'm assuming someone who could get money from the treasury or something like that, right? He goes to him and then he shows how the counterfeit process works. How the counterfeit process works. So I think he like shows the machine and shows the process of it, and he just explains how this whole thing is going to happen. Now, at that instance, when someone says, oh, look, I really, really want to print money, let me show you the entire process of it. At that point, you would assume that he's attempting to print money, right? But under the Sri Lankan law, no, that's still preparation, right? Only when you tell the other person, okay, bring money, we will start printing it and actually get hold of the money, that's only when you actually made an act to commit the crime. So under this case, it says when the person requested to get 610,000 notes from the government treasury delivered, that's only when there is attempt, right? So it is not when he explained how the act is to be committed, that's also preparation. It's only when he tried to do something that is actually print the money that we say there is attempt. But if you see here, just trying to print the money, like, okay, give me the 600,000, we will start printing it, right? Does that really fall for the possible intervention theory? Not really, right? You can still ask that person for 610,000 rupees and still later repent. But, under the Sri Lankan law, we don't really care about the possible intervention theory. We simply seem to care more about the last act theory, which is like you did not even last act, you did something towards the commission of the crime. That's enough, right? So it's kind of like this middle ground where you have gone beyond the preparatory phase and you are going to commit the crime. That's all that the Sri Lankan law wants. It doesn't exactly fit itself into any of these tests or theories, right? So here the legal principle basically says there is a difference between preparation and attempt, demonstrating the method and the statements that he made saying we are going to do this is simply preparation. Only when he requested the 600 notes and made an act towards committing the offense does it amount to attempt. So what you should keep in mind is under the Sri Lankan law, only when you make an act towards committing the offense does it amount to attempt. Okay? Right. So here it says cheating is a series of acts beginning with the inducement of deception. So for cheating is crime. The first thing that you start with is deception. The second thing that you do is making the other person part with their property, right? Making the person part with their property. This is what was held in this case as well, King versus Silva. And according to the Sri Lankan courts, simply deceiving is not attempt. However, making at the point that you make the other person part with their property, that is when it is attempt, right? So let me explain it with this case, King versus Silva. We have a very interesting looking case here. We have a person who's trying to, let's say A is trying to cheat this person called Mr. Herman, right? And he's saying, oh, there is this like really wealthy guy who really, really likes gambling, and he is willing to gamble for a lot of money. And A shows Mr. Herman a card trick, and he shows how in this card trick he can manipulate a card deck and thereby cheat this other person. So this detective will call him C. So A tells Herman, there's this card trick that I know. There's a card trick that I know, and we can use this card trick to trick C. So Herman is like, wait, aren't you cheating? Isn't that a bad thing to do? But A is like, no, it's completely legal. That's completely fine. And let's go do it. So in this instance, Mr. Herman was invited to the gamble, and he forgets to bring money in cash. He doesn't forget to bring money. He purposefully doesn't bring money because he knows that he's going to be cheating C, and he didn't want to do that, right? So A is an innocent party. If you look at the actual case facts, H is an innocent party. He didn't want to trick C. So he wanted to tell C that A is trying to cheat him. He wanted to tell C that. So that's why he didn't bring money. But then when he came into playing the gambling and all of that, he realized that A and C were accomplices. These people were accomplices, and A and C were trying to trick him. This was not going the other way around. This is a very complicating case to read, by the way. Okay, so here he realizes that the Chetty was not wealthy and was working with the accused to cheat Mr. Herman. So the second time he was like, okay, I will catch them both. So the second time what he does is he again agrees to the gambling. He says, this time I will bring the cash with me, and he goes to the gambling place. But this time he brings a police officer. Now the issue was the police officers caught A and C before the gambling properly began. Now, the gambling did sort of begin, but it didn't exactly properly begin, because what happened, we have A, C, and H, and both of them were like sort of playing the card trick. They were halfway through the card trick, halfway through, not necessarily halfway through, but like somewhere through the card trick. But even after they were somewhat through the card trick, in no instance did they ask Mr. Herman to part with his money. They didn't ask Mr. Herman to put his money on the table so we can start gambling. Now, if they had, right? If they had asked Mr. Herman to put the money on the table and basically asked him to part with his money, they wouldn't have just achieved deception. They would have made the person part with their money. So if at that point the police came and caught them, attempt would have been established. But still, because that part was not established, right? Because they did not make Mr. Herman part with the money, too bad there was no attempt, right? The police came a bit too early. So here the court said that cheating has two elements. You have deception and you induce the other person to deliver money. It's not parting with their money, but you encourage them to uh, put their money on the table or leave their money or leave their property out. So since they did not tell Mr. Herman at any point to put the money on the table, and before they could do that, the police caught them. The court was like, too bad, there's just no attempt here. Right. So there was abetment, which we'll talk about later, but there was no attempt in this case. Next case, Kensington versus Edrisinger, an important case when it comes to preparation, right? In this case, we have two people who were in a heated argument. We have A and B who were in a heated argument. While this heated argument was happening, A ran away and asked from a chettiar to give him a knife. He was like, give me a knife. So when someone says, okay, give me a knife, when they were in a heated argument, it's quite clear that why he wanted the knife. It wasn't like go home and cut vegetables, right? It was to kill party B. But in this instance, before he could kill party B, some intervening act occurred and he couldn't do it. But still, B sued A and said he attempted to voluntarily cause hurt with a knife. The court said simply going out there and getting a knife, even though they were in the middle of a heated argument, is not attempt but rather preparation. So thereby he was acquitted, because according to the court, devising and arranging means and resources to commit the offense is not commission of the offense or is not attempt. If you take the knife, run towards that person and say something like, oh, I'm going to kill you, or if there's a direct action towards causing hurt, that is only when there is attempt, right? Attempt to cause grievous hurt cannot be established by simply taking action to turns necessary, right? Okay. Hope that made sense. So we did Kacheri Mudaliar versus Mohammedu, so I'm not going to do that again. And then we have Regina versus Eagleton. This is not a case in Sri Lanka. But you can use this for like English law principles, right? So the case was Eagleton was a baker who contracted with a parish to provide bread from an agreed weight to the poor for exchange of tickets. But the issue was he sold underweight bread. And before he received the money, now he intended to do this, by the way, before he received the money, he was caught. In this instance, the court was like, wait, was there attempt? Because he was caught before he could actually get the money. He still sort of did have time to repent, didn't he? But still, the court said, based on the last act theory, all that was left for him was to receive the money. He had done his Somebody is recording. Thank you so much. Right. Let me remove this 1 second. Right. So two things to look at here: physical impossibility and legal impossibility. Physical impossibility is basically I could not have attempted to commit the crime because it was impossible to commit the crime. So let's take the example case of Collins. Now, in the case Collins, it was established that if the person put his hand into someone else's pocket to steal his money, but there was no money in the first place, he still attempted to steal money. And this physical impossibility test is actually there in section 490. I have not mentioned it in the note here, but if you look at the two illustrations or explanations that are there in section 490, there is one illustration which talks about um, even if you could not have committed the crime, if you had the intention of committing the crime and you made an act towards committing the crime, that means there was an attempt, right? So this is an interesting thing. We always talk about this physical impossibility thing when we talk about like things like murder, right? We're like, oh, it was not possible, not murder, sorry, things like theft. It was not possible to have committed theft because in that instance, there was nothing to steal. So there can't have been theft. But still, there can be attempt to theft because there are two things established. One, you have the intention of committing theft, and secondly, you made an act towards committing theft. Committing theft. If both of these two things are established, even though there that does not mean there's no attempt. So even if it is physically impossible to have committed the crime, as long as you had made an act towards the commission and you had the intention of committing it, that means there was attempt. And this was established in the case King versus Giris Appu, but you really don't have to look at case law for this because the two illustrations under 490 are explaining it, right? Okay, so then we go into, okay, there's another one, which is the objective reasonableness test. Now, if it is absolutely factually impossible to have committed the crime and a reasonable person would have realized that it's factually impossible, we don't say that there's attempt. So, for instance, if a reasonable person knows that you can't kill someone with a water gun, but there is person B who thinks, oh, I'm going to kill that person. He thinks a water gun can kill someone. He shoots a person with his water gun. So, in that instance, he had the intent, but and he also committed an act towards the crime. Towards the crime. Now, both of these things were there, but is there attempt? Not really, because a reasonable person would realize a water gun cannot kill a person. So, because it is not reasonable, because that is missing, we say that there is no attempt. So, again, you have to look at this objective reasonableness test. If someone attempts a crime which a reasonable person would not have, then that is not an attempt. Just keep that in mind as well. Okay, so legal impossibility is basically when, these are like the exceptions that exist. So, for instance, a person of unsound mind committing an act or attempting to commit an act. If if his act could not have been a crime on a normal sense, then the attempt cannot be a crime as well. Let me take, for instance, there is a person of unsound mind. We have A, he's of unsound mind, and he tries to murder D. Okay, he tries to murder D. Now, D escapes, right? He escapes, so there was no murder. But can we say A attempted to commit murder? No, because A could not have murdered in the first place legally, right? Because under, I think it was section 76 of the Penal Code, there is an exception which says that people of unsound mind cannot commit crimes. So if the crime itself cannot have been committed, the attempt of the crime cannot be legally committed either. Okay, that was a very simple thing. I'm just going to go through that again. Okay, is there anything in this whole thing that you guys would want me to repeat? Would you like to have a quick recap of it? If not, we can go for the questions. I'll give like 2 minutes. Okay. All right. Questions it is. Right. So first question. Sena, a musician, is found to have been in the company of 5 children at his residence. Police said that the parents have complained that their children are picked from school by Sena and he drops them back in the evening, and it happens often. Okay. So the police are trying to charge him for attempt of committing sexual harassment. But we say that we can't charge him under that, and let's try to explain why. So obviously in this red, you can see the answer is not this long. It's a very, very long answer. It does not have to be this long. It's a very short answer, I think, that we have to write here. But in this answer, I will put this to the group as well. I am giving a quick summary of attempt in general, right? So if this was the only question that was there, let me show you the question itself. If this was the only question, let's say this was this question only, I would have written this long answer. But since there are 3 questions, I wouldn't reasonably write this long an answer, right? So this whole thing, I don't think I have to go through. I'm talking about the wrongful act theory. So just a structure of my answer. I'm explaining what attempt is. Then I'm going through 490, and I'm also talking about like the specific provisions that are there. Then I go into like, oh, there are several theories. So first I start with the wrongful act theory. Actually, let me break down each of these theories for you, right? So under the wrongful act theory, I say that attempt is committed when a person commits one offense in pursuance of another offense. So in Sri Lanka, we do reject this theory. Now, in Sena's case, the wrongful act theory would establish attempt. Why? Because he committed the offense of kidnapping in pursuance of sexual abuse. So if you commit one offense pursuing another, that means there is attempt according to the wrongful act theory. But since this is not a theory that Sri Lankan law cares much about, we'll just ignore it. Next one, we have the first stage theory. So which is about a subjective theory, right? So it's like, oh, if the person believed the first act that he's committing is an act towards the offense or towards committing the offense, then he had committed uh, attempt of that offense, right? So we don't follow this theory, but let me explain how it would look like in Sena's perspective here. I have not mentioned it here. So if Sena believed that kidnapping children is the first act towards sexual abuse, then there is attempt. But then again, since that's too subjective, we cannot really consider that. And we can even say that Section 300 looks at these things like preparatory acts. And in Sri Lanka, preparatory acts are not part of attempt. Preparatory acts are different. Okay, so then we have the perpetration theory or the intermediary act theory, which says any act in between, between the first act and the last act can be constituted as attempt. Again, since we don't really know what will amount to an intermediary act, we can sort of ignore this. Right. Then we go into the final stage theory. Has he committed the final act that is necessary for sexual abuse? No, he has not. Because in the facts, it does not say that he has done anything towards the commission of the crime, right? It just looks like he kidnaps these children and just keeps them in his house. There is no factual evidence saying that he has made any advances towards them or he has done any act to commit the crime of sexual abuse. So in that case, we can simply say that, oh, he has not attempted it. Questions. Do we need to talk about all the theories inside the issue? No, we don't. We don't in this question because in this question, it basically has 3 parts in it. So I don't think it is necessary, right? But even though we don't have to talk about all of them, I would think if it's like one of these questions, like if it was just Sena, the musician, and the five children, if that was the only question, there's not enough to talk about to get uh 20 marks, right? So in that case, I would say maybe talk about all of them. But it depends on the number of marks that you get and how narrow the question is. I won't be able to like perfectly tell you that in this instance you have to use it, right? Just look at the marks and look at how long your question is, and you can kind of decide whether you have to talk about all the theories or you can simply just get away with talking about the most important theory. Right. So then, according to the final stage theory, we can say there is no attempt either because he has not committed the final act. But if we look at the equivocality test, does Sena kidnapping these children unequivocably for sure show that he's going to commit sexual assault? No, it does not, because like I said before, he could have committed so many other things, right? So because of none of these theories perfectly fitting into it, we can say that there is no attempt. But let's look at the Sri Lankan version of it, right? In the Sri Lankan version, we look at preparatory act and then any act towards the commission of the crime. So we can say that simply kidnapping a child would amount to preparation and not really committing the crime. If he was committing the crime, he would actually have to be dangerously proximate towards the final, the final goal, which is sexual abuse. And since he has not done anything like that, there is no attempt. But even though there is no attempt for sexual assault, we can say that he can be liable for kidnapping. I don't remember the section for that, but he's liable for that, right? Okay, so that is everything under that. So for here, there's another thing that you must establish. You must say that sexual assault is something that is there in the penal code. I think this is something you should establish first, is something that's there in the penal code, and the punishment is imprisonment. If these two things are satisfied, that means 490 can be used. But in this instance, since he has not really reached any proximate stage, we can say that even if 490 could have applied theoretically, it won't apply just because this was just preparation, right? Hope that makes sense. Moving on, second question. Sena goes to an electronic devices shop and inspects the mobile phones. One of the salesmen brings a new phone from the store and shows it to another customer and then packs it into a box. Sena slowly takes the box and puts it in his pocket. Sena goes out, passing the payment counter as if he had not purchased anything. While he approached the entrance, a security guard who was watching the CCTV footage stops him and does a body search. Okay, so he attempted to commit theft, but he was stopped. There was an intervention, right? But this question continues a bit forward and says the phone box found inside his pocket was empty because he had picked an empty box in the rush. Okay, so we see factual impossibility here. Factual impossibility. Right. So what we have to establish here is, was there preparation or did he go beyond preparation? I mean, rationally, if you look at this question, you can sort of say, okay, first thing that you establish, is there mens rea? Yes. Mens rea, yes. Under the Sri Lankan law, is there mens rea? Yes. Under the English law, is there mens rea? Yes. Because there's clearly intention to steal. Because when you look at a phone box and you put it into your pocket, you clearly do have an intention to steal. So under both the English law and the Sri Lankan law, mens rea is established. So then we look into actus reus. Under the Sri Lankan law, to establish actus reus for attempt, it should be something which falls under the provision of 490. If it doesn't fall under the provision of 490, too bad, you can't have attempt, even though there was actus reus, right? So when we look at theft, I think I don't remember the section for it. Theft is section 367. So theft is section 367 and the punishment is imprisonment in this as well. So thereby 490 will apply. Under the English law, doesn't matter, it will apply to any offense. Okay, so we look at the actus reus here and try to figure out how far has he come into committing the crime? Has he gone beyond the preparatory stage? If he has gone beyond the preparatory stage, we establish actus reus. Okay, so puts it in his pocket. Is that preparatory or has he moved towards commission of the crime? I mean, if we go with the last stage theory, we'll say that it's preparatory, right? Because it's still him preparing, right? He still hasn't walked out. He still hasn't like done anything towards making the other person part with the property. He just hid it, right? So hiding something, not yet theft. Trying to go out with the property without buying it, now that is theft. So putting it in his pocket would have been preparation, but passing the payment counter and trying to go outside, that is moving past preparation into commission of the act. So we can say he moved past preparation, so actus reus necessary for attempt was established, right? So here you can use all of these case laws and say that, like you can even use Kensington versus Etherisinghe. You can say, oh, in that instance, that was preparation, that was not considered. But in this case, he did something to commit the crime, and thereby the court said there was attempt. So in the same way, you can say here, he did something to commit the crime by trying to walk out. So that means there is attempt. So just use case law here and there for that. But then factual impossibility, right? We said under section 490, we don't care about factual impossibility, right? There are just two things that we have to care about. Was their intention? Was there any act towards the commission of the crime? Commission of crime. If both of these two things are there, even though it was factually impossible to have stolen that phone because there was no phone in the first place, too bad, there's still attempt of theft. Right. Hope that case made sense. There is a special case that I have mentioned here, Abhevardhana versus Muthunayagam. This was something that I saw last moment. In this case, it said that a person may be guilty of an attempt to cheat even if the intended victim was not actually deceived. So let's say we have A and B. A was trying to cheat B, but B is someone who knows about this, right? He properly has knowledge about this. So even though factually it was impossible to cheat B, if A intended to do it and tried to cheat B, that's still attempt to cheat. It doesn't matter if it was factually impossible to cheat him. Another case is Rex versus Fernando. In this case, it was established that if a person tries to cause miscarriage to a woman, like tries to force miscarriage on a woman, even if that woman was not pregnant, there is attempt of causing miscarriage. Why? Because it doesn't matter if it's factually impossible as long as he had the intention and he genuinely thought she was pregnant and he was doing an act in order to create miscarriage, right? Okay. So under those are just two other cases which re-establish the principles that are there in the illustrations of 490. But I think you don't have to do those. You can just rely on the illustrations of 490. Next, Sena is found in a car park trying to insert a key into the keyhole of a car that is parked. He's arrested by the police on the suspicion, and the investigations reveal that he does not own the car, but had in his possession a bunch of car keys. So he was charged for attempting to steal. So again, you establish intention if you had too many car keys and you were trying to put the keys into a car that you do not own. But there is clearly intention when it's not just one key, right? You have a lot of keys that does not belong to you. So in that instance, you want to steal, right? I mean, if it was one key, at least he could defend and say, well, I just mistook my car for this car. It's not my fault. Then it's really hard for the prosecution to establish intention. But if you had a bunch of keys, it's quite clear that you were trying to steal. So it's easy to establish intention here. Then the second thing is the actus reus here. So we already established that theft is something that falls under the penal code as imprisonment. So 490 will apply. So Then Actus Reus, how far did he go with it? He seems to have gone pretty far, right? He hasn't just made the keys and gotten the keys. He hasn't just gone into the car park. He actually tried to insert the key as well. So he has basically committed the final act necessary. So yes, there was Actus Reus, and thereby there was attempt. Very simple. But once you have like addressed the questions before, I think addressing the final question is not going to be too hard. Okay, that's pretty much it. I hope everything made sense. I will send this note again. I will fix my note a bit more. I feel like there are a few things that I can fix here. I will fix them and send them. Are there any questions? I understand that I might have been confusing in some instances. So are there any questions? I will take that as a no. But if you have any questions like later on as well, please do feel free to ask on WhatsApp. And if you do have anything to add to it, and I don't know if you're shy to add to it right now, you can always put it to the group and say, in addition to what you said in the recording, this thing is also true, or what you said is wrong, or whatever. Just put to the group once the recording is put as well. And thereby, so thank you so much for joining. Have a good night.